Denzel Washington stood calmly at the lectern in Supreme Courtroom 3, his navy blue suit sharply contrasting the grand marble pillars behind him. Moments earlier, Chief Justice John Roberts had broken with usual courtroom decorum to confront him directly. "Mr. Washington," he said, "I find it hard to believe that someone with your background truly understands the constitutional implications of your position." The comment stunned the courtroom. Law clerks glanced at each other. Seasoned attorneys sat upright, and journalists scribbled furiously. Yet Washington, an acclaimed actor who had secretly studied law for 5 years while filming blockbuster movies, remained unshaken. The 9 justices and the full gallery watched him closely. Roberts, with his Harvard education and 16 years, as Chief Justice, had expected to reveal flaws in the celebrity's legal thinking. But Washington came equipped with a deeply researched constitutional theory and a remarkable grasp of legal precedent. What started as a dismissive challenge was about to become one of the most memorable oral arguments in recent court history. This wasn't just another case. It was Washington's opportunity to show that legal brilliance can emerge from unexpected places and even reshape constitutional interpretation. Before we dive further into this dramatic courtroom showdown, don't forget to like this video and subscribe to our channel. We bring you stories where dedication meets opportunity. The anticipation around this hearing began building 3 months earlier, when Washington filed an amicus brief in Henderson v. Department of Justice, a case concerning civil forfeiture laws that disproportionately impacted minority communities. Legal professionals initially dismissed the brief as a publicity stunt. Few knew that Washington had earned his law degree from Howard University, studying nights and weekends in private, never revealing his second career. Chief Justice Roberts, age 67, ran the court with seasoned confidence. His resume included Harvard Law, a clerkship for Justice Rehnquist, time as Principal Deputy Solicitor General, and nearly 20 years on the High Court. He had a reputation for sharp and often piercing questions that could unravel weak arguments quickly. When Washington was granted 10 minutes to argue on behalf of the petitioner, a rare privilege for someone submitting an amicus brief, speculation ran wild. Many believed it was a PR move by the court to seem more accessible to the public, but those who actually read Washington's 40-page submission recognized it offered a fresh legal argument about the Fifth Amendment's takings clause, one that challenged years of established precedent. "I can't believe they're letting him speak just because he's famous," whispered one corporate lawyer in the gallery. "This isn't a movie set. You can't just memorize lines and impress the Supreme Court." The stakes were high. Henderson dealt with the government's seizure of a community center and nearby properties in a mostly black Philadelphia neighborhood, all based on a single drug deal that took place on the sidewalk. None of the property owners had been charged with a crime, yet millions in property had been taken under civil forfeiture laws. If Washington's position succeeded, it would significantly limit the government's power to seize property without criminal charges. If he failed, not only would the property seizures remain in place, but Washington's legal theories would likely be dismissed as the work of a well-meaning but unqualified celebrity. The courtroom grew still as Washington stepped up. Unlike many first-time advocates, he didn't appear nervous. He moved with the steady poise of someone used to performing under pressure, but few anticipated just how well prepared he truly was. Washington began, his deep voice resonating through the courtroom without any need for amplification. "Mr. Chief Justice, and may it please the court," he said, "the Fifth Amendment's guarantee that private property shall not be taken for public use without just compensation was originally understood to require more than payment. It also demanded a clear public purpose and basic legal protections before the government could take someone's property." His opening was smooth, but not especially provocative. Chief Justice Roberts, who had reviewed the brief with skepticism, interrupted just 40 seconds into the argument, a rare break from protocol. "Mr. Washington," Roberts said, a hint of condescension in his voice, "I appreciate your interest in this case, but I struggle to believe that someone from your background fully understands the constitutional implications of your position. Your brief overlooks over 200 years of precedent on civil forfeiture, Gasps and whispers rippled through the room at the unusually personal tone of the question. Justice Sonia Sotomayor shifted uncomfortably. Justice Elena Kagan frowned. Washington paused and met Roberts' gaze squarely, a calm often seen before his most memorable on-screen performances. Chief Justice Roberts. He replied evenly, "I believe my argument is aligned with the historical meaning of the Fifth Amendment, as Justice Thomas discussed in his concurrence in Timms versus Indiana. But perhaps we should examine the text and the historical evidence together." He opened a well-used copy of the Constitution and placed several original documents on the podium, rare for a court appearance, but evidence of his meticulous preparation. Something in his method caught Roberts off guard. This wasn't a surface-level argument from a celebrity guest. This was serious legal scholarship. Roberts leaned forward and tried a deeper challenge. "Mr. Washington, your brief claims that civil forfeiture was originally limited to admiralty and customs contexts, where courts couldn't reach property owners. But you didn't account for the Palmyra, an 1827 case where we affirmed broader government forfeiture powers. It was a trap. The Palmyra had misled many attorneys before, but Washington didn't miss a beat. With respect, Chief Justice," he said, "I did address the Palmyra. See page 23 of my brief." He turned to it instantly. While the case allowed forfeiture without criminal charges, it was strictly about maritime piracy. As Justice Story explained, the ship itself was treated as the offender. That legal fiction made sense when personal jurisdiction was impossible. He continued, his voice gaining strength. But Story never implied this rule should apply to domestic cases against American citizens. I've reviewed every civil forfeiture case from 1789 to 1850, 27 in total, and every single one involved maritime seizures, customs violations, or piracy. Not one involved land-based property taken from innocent owners. The room went silent again. Washington hadn't just read the Palmyra. He had done a full historical review that few academics, let alone practicing attorneys, had ever attempted. Justice Samuel Alito, often supportive of law enforcement, spoke up. "That's a compelling historical point, Mr. Washington. But how do you address more recent rulings like Brilliance versus Michigan, where we upheld the forfeiture of a car from an innocent owner?" "I believe Brilliance was wrongly decided," Washington replied, drawing a surprised reaction from the audience. "Challenging Supreme Court precedent is always risky. And I'm not alone. Justice Thomas, along with Justice Ginsburg, strongly dissented. More importantly, Brilliance created tension with later cases." He flipped another page. "In Austin vs. United States and Timms versus Indiana, this court held that civil forfeiture is quasi-criminal and must follow constitutional limits. This case gives the court a chance to resolve those conflicts." The courtroom atmosphere shifted. Justices who had initially seemed skeptical were now taking notes and leaning forward. Court observers noticed Justice Clarence Thomas, known for his silence during arguments, was unusually attentive. Justice Brett Kavanaugh stepped in next. "Mr. Washington, your historical argument is persuasive, but practically speaking, civil forfeiture has become a key tool for law enforcement. Are you saying we should do away with it completely?" "Not at all, Justice Kavanaugh," Washington responded. "I'm saying the court should return civil forfeiture to its original limits. It's still appropriate for customs, admiralty, and cases where the owner cannot be brought to court. But when the government can file criminal charges and chooses not to, yet still take someone's property, both due process and the Fifth Amendment require more." Roberts, now more engaged with the substance than the speaker, changed direction. "Your brief cites some obscure early state court cases that even most scholars don't reference. How do we know they reflect mainstream legal thinking rather than isolated views?" Washington nodded slightly. This was the moment he'd anticipated. "I appreciate that question, Chief Justice. These cases aren't outliers. They show a consistent pattern across states. From memory, he explained 8 state Supreme Court decisions from early American history. Each case, he argued, upheld a narrow understanding of government seizure powers, and none allowed the kinds of forfeitures being practiced today." Justice Elena Kagan interrupted, visibly impressed. Mr. Washington, your historical research is outstanding. Did you work with legal historians to prepare? For the first time, a hint of pride touched Washington's voice. No, Justice Kagan, while I consulted respected scholars, the primary research, going through archives, reviewing original documents, I did myself. I started it during law school at Howard, and continued since graduating. The courtroom buzzed. Many were just now learning that Washington had actually earned a legitimate law degree. Justice Sotomayor picked up the line of questioning. Mr. Washington, focusing on this case specifically, how does your historical view apply to the community center seized in Henderson? Turning to her directly, Washington replied, Justice Sotomayor, under the original understanding I've outlined, the seizure in Henderson is unconstitutional in several ways. First, the only illegal activity was a drug sale by someone else on a public sidewalk. The link to the property is extremely weak. Second, the government never showed the owners knew of any wrongdoing. And third, the scale of the seizure is completely out of proportion to the harm. He paused before making his strongest point. Most importantly, this forfeiture fails the public use test under the Fifth Amendment. Taking property and putting the proceeds into general government funds, rather than addressing a specific harm, doesn't meet the standard the founders expected. Court officers quietly extended Washington's speaking time, a clear sign of how seriously the justices were taking him now. What began as a chance to put a celebrity in his place had transformed into a moment of real legal significance. And Washington wasn't done. By now, the mood in the courtroom had entirely shifted. What began as doubt about a Hollywood actor's qualifications had turned into a serious legal discussion that captivated the court. Washington's knowledge of case law and constitutional history was proving to be deeper than many seasoned attorneys. Chief Justice Roberts, now fully focused on the legal argument rather than the advocate's fame, began to understand he may have seriously underestimated Washington. The attempt to discredit him had backfired. Instead, Roberts had unintentionally given him the perfect opening to demonstrate a profound understanding of constitutional law. With the courtroom fully engaged, Roberts shifted tactics again. Mr. Washington, your historical work is certainly detailed, but I'm still troubled by the broader consequences. If we adopt your framework, what happens to all the forfeitures already carried out under current law? Have you considered the legal and practical disruptions? It was a valid concern, one the court regularly weighs when revisiting precedent. But Washington was ready. Yes, Chief Justice Roberts, he answered, pulling out a document that appeared to contain detailed figures. I've examined data from the Department of Justice's asset forfeiture program over the last 10 years. Based on that analysis, roughly 87% of current forfeitures wouldn't be affected by my proposed standard. These include cases involving unclaimed property, customs violations, and property tied to criminal convictions. He turned the page. The remaining 13%, those involving innocent owners and no criminal charges, are the ones at issue. These cases cause the most harm and pose the greatest constitutional problems. They're also the most inconsistent with our founding principles. Justice Amy Coney Barrett entered the discussion. Mr. Washington, your brief makes a novel point about the relationship between the Due Process Clause and the Takings Clause. It's a connection I don't think I've seen any legal scholar make before. Could you expand on that? Washington nodded. Thank you, Justice Barrett. While the two clauses are usually treated separately, early American legal thought viewed them as connected. When the government takes someone's property without proper legal procedures, it isn't just a due process problem or just a takings issue. It's both, he continued with growing energy. James Madison, who wrote, both clauses talked about this connection. In a 1788 letter to Jefferson, he warned that arbitrary property seizures violated both procedural fairness and the core right to ownership. From his folder, Washington produced a photocopy of the original handwritten letter. I found this while reviewing the Madison papers at the Library of Congress. To my knowledge, it hasn't been cited in a civil forfeiture case before. In it, Madison describes such seizures as a double violence against the most sacred of rights. The courtroom was silent again, not from doubt, but from respect. Justice Clarence Thomas, who rarely speaks during oral arguments, finally joined the conversation, causing reporters to sit forward, ready to document every word. "Mr. Washington, your originalist approach is refreshing. You've shown that today's forfeiture laws go far beyond what the founders envisioned. But tell me, how would you distinguish this case from Bennis? Are you asking us to overturn that ruling directly?" It was a significant question. The court is generally reluctant to overrule past decisions unless absolutely necessary. Washington answered carefully. "Justice Thomas, I do believe Bennis was wrongly decided, but I'm not asking the court to overturn it outright. That case involved a vehicle directly used in illegal conduct, which at least has some connection to early forfeiture practice. In contrast, Henderson involves a community center and property with no direct criminal use. The court can distinguish these two situations and still clarify that civil forfeiture must meet both historical limits and constitutional protections." His response struck the right balance, respecting precedent while showing a clear path forward. It also reflected strong understanding of how the court works. Washington wasn't just offering a legal theory. He was offering the justices a way to rule decisively without disrupting their broader principles. The shift in tone from the bench was unmistakable. Where earlier questions had carried skepticism, now the justices were inviting Washington to shape the future of constitutional law. Chief Justice Roberts, now fully engaged with Washington's argument, posed a final substantive question, the kind usually reserved for top-tier advocates. "Mr. Washington," he asked, "if we were to adopt your framework, what specific test should the court use to evaluate civil forfeitures in future cases?" The courtroom sensed the significance. This wasn't just a challenge. It was an invitation to help shape constitutional doctrine. Washington didn't hesitate. "Chief Justice, I propose a three-part test rooted in both the original understanding of the Constitution and this court's recent rulings in Austin and Timms," he said, raising three fingers as he spoke. "First," he began, "the government must prove a substantial link between the property and specific criminal activity, not just a loose association like in this case." Second, he continued, "if the property owner is within the court's jurisdiction, due process requires one of two things: either a criminal conviction or clear and convincing evidence that the owner knew about and consented to the illegal use of their property. And third," he concluded, "any forfeiture must serve a genuine public use, not just raise revenue. The government must show how the forfeiture addresses a specific harm or need." He spoke plainly but with authority. This test honors the Constitution's text, reflects historical practice, and gives clear standards to lower courts. Most importantly, it protects innocent people from having homes, businesses, and community spaces taken without real justification. As Washington finished, an unusual moment followed. Complete silence. Normally, the Chief Justice would announce that a speaker's time had expired. Instead, no one said a word. Justices kept writing. Others leaned back, digesting what they had just heard. Finally, Roberts spoke, his tone far different from how he had started the session. "Thank you, Mr. Washington. Your argument has been exceptionally informative." That short sentence carried weight. It was a clear acknowledgement that Roberts' earlier attempt to undermine Washington had not only failed, it had backfired. Washington hadn't just held his ground. He had delivered a legal argument worthy of the court's highest regard. As Washington returned to his seat, the government's lawyer walked to the lectern, visibly shaken. The dynamics had completely shifted. What had begun as a routine defense of government power had turned into a far more difficult case, with justices from across the ideological spectrum intrigued by Washington's historical and legal claims. Outside the courtroom, the impact was immediate. Legal analysts were already calling the argument historic. Law professors began assigning transcripts of the hearing to their students. Legal blogs lit up with commentary, many praising Washington's analysis as one of the most thorough and persuasive originalist critiques of civil forfeiture ever presented. CNN's senior legal analyst summed it up succinctly. "I've covered the Supreme Court for over 2 decades, and I've never seen anything like this." Denzel Washington didn't just hold his own. He delivered a performance that could shift legal doctrine. The buzz extended beyond legal circles. Clips of Washington calmly quoting obscure case law and Madison's letters began trending across social media. Hashtags like Tamar Legal Scholar Denzel and Tana Denzel Teaches the Chief gained traction. Viewers who had grown up watching Washington's films were now discovering a new respect for his intellect and preparation, but there was more to come. Just 3 days after the argument, the New York Times published a detailed profile confirming what had only been hinted at in court. Denzel Washington had earned his J.D. from Howard University, with top honors, studying law while managing his film career. According to the New York Times profile, Washington had pursued his legal education in complete secrecy. He had taken night classes, studied on film sets, and submitted every paper and exam himself, never using his fame to gain favor. His professors at Howard described him as focused, humble, and driven by a deep interest in constitutional law and civil rights. He never asked for special treatment, said Professor Marcus Johnson, who had taught Washington in his constitutional law class. Most of the students didn't even recognize him at first. He was just another serious scholar with a commanding presence. The article revealed that Washington had quietly funded scholarships for underrepresented students in law, always anonymously. His motivation for studying law had not been publicity or career reinvention. It had been a long-standing passion for justice reform and a desire to make a lasting difference beyond his public persona. In the days following the argument, legal commentators and podcasts began dissecting every part of Washington's presentation. Special attention was given to how Chief Justice Roberts had opened with skepticism, even personal condescension, and how that dynamic had dramatically shifted over the course of the hearing. By the end, Roberts was treating Washington as a serious peer. Nina Totenberg of NPR summed it up. What we witnessed was a real-time recalibration of assumptions. The Chief Justice expected a showman and found a scholar. His change in tone was subtle, but unmistakable. It reminded us how bias, even subtle professional bias, can cloud judgment, even in the highest court. Meanwhile, the American Saxe Bar Association invited Washington to deliver the keynote speech at their upcoming national conference. Law schools across the country saw a spike in applications from students of color, with many citing Washington's example as motivation to apply. On social media and legal forums alike, people began debating not just civil forfeiture policy, but broader issues around who is welcomed into elite legal spaces and who is underestimated before they ever speak. Through it all, Washington remained modest. At a movie premiere the following week, a reporter asked him about the Supreme Court hearing. He replied simply, "The law, like acting, rewards preparation. I'm just grateful I had the chance to make a constitutional argument. Hopefully, it moves the conversation forward." 6 weeks after the hearing, the court issued its decision in Henderson v. Department of Justice. In a 7-2 majority, the justices ruled in favor of the petitioners, sharply curbing the government's power to seize property under civil forfeiture. Though the opinion didn't mention Washington by name in the author credit, Chief Justice Roberts himself wrote the majority opinion, a move many viewed as a gesture of respect and self-correction. Roberts wrote, "After a thorough review of both historical sources and constitutional text, the court finds that modern civil forfeiture practices have significantly expanded beyond the limits intended by the founders. While the practice remains lawful in specific contexts, the Constitution does not allow the government to take property from innocent citizens based on weak or indirect links to criminal acts, especially when that property plays a vital role in serving the community." Even more remarkably, the opinion quoted Washington's oral argument in 4 separate places, including his proposed 3-part test. A footnote in the ruling explicitly praised the amicus counsel, Washington, for exceptionally thorough historical research that clarified original property protections under the Constitution. Justice Thomas issued a concurring opinion that went even further, calling for a full reevaluation of all civil forfeiture law under originalist principles. Justice Sotomayor's concurrence emphasized the harm these practices had caused in marginalized communities, using the data Washington had presented during the hearing. Perhaps most strikingly, Chief Justice Roberts added a personal reflection in the final paragraph of the court's opinion, a highly unusual move for a Supreme Court ruling. He wrote, "This case serves as a reminder that legal insight can come from unexpected sources. Our judicial system is stronger when it listens to diverse voices and engages deeply with every well-reasoned argument. The court benefited greatly from the thoughtful advocacy and historical research offered in this matter. The effects of the decision were immediate. Several states began reforming their civil forfeiture laws to align with the new constitutional standards laid out by the court. Property that had been seized under now invalid legal grounds, homes, businesses, and community buildings, was returned to its original owners. Law enforcement agencies were forced to focus more narrowly on seizures connected to actual criminal convictions, rather than pursuing vague or unsupported claims. For Denzel Washington, the aftermath marked the beginning of a new chapter. While less, he continued acting and directing. He also launched the Washington Justice Initiative, a non-profit aimed at providing legal help to communities disproportionately affected by civil forfeiture and property rights abuses. Law schools across the country invited him to speak on constitutional law and the founding principles of property protection. 6 months later, Washington and Chief Justice Roberts appeared together at a public forum hosted by Georgetown Law School. The event focused on civic education and constitutional interpretation. Their discussion was marked by professionalism, mutual respect, and even moments of humor as they recalled their tense courtroom encounter. At one point, Roberts publicly addressed what many had observed throughout the legal community. "Mr. Washington taught me something valuable that day," he said. "We should never confuse fame with ability, and never assume that someone who takes a different path to the law is less qualified." His argument in Henderson will be studied for years to come. Washington responded with humility and grace. "The beauty of our legal system," he said, "is that when it works as it should, the merit of an argument matters more than the person making it. I'm thankful the court was willing to consider the issues seriously, regardless of how unusual the messenger may have seemed." That exchange, widely shared across media outlets and social platforms, became a modern parable for how respect, preparation, and open-mindedness can reshape institutions. It also served as a reminder of how far society still has to go in recognizing expertise in unexpected places. Law school orientation programs began featuring the Henderson case as required reading. Some used it to teach constitutional law, others to discuss bias and professionalism in legal settings. The story of how a Hollywood legend walked into the nation's highest court and delivered a transformative legal argument inspired a generation of aspiring lawyers, especially those from non-traditional backgrounds. In classrooms and courtrooms across the country, Washington's performance wasn't viewed as a celebrity moment. It was a turning point in how legal authority is understood and earned. The notion that ideas should rise or fall on their substance, not on who speaks them, gained fresh relevance. The story of Henderson versus Department of Justice became a symbol of justice pursued through preparation, of prejudice overcome by performance, and of a system that, at its best, listens to truth no matter who delivers it. Thank you for following this incredible journey through one of the most surprising and powerful Supreme Court moments in recent memory. If you found this story as inspiring as we did, please like this video, subscribe to our channel, and leave a comment about how you think preparation and open-mindedness can help reshape the legal world.